And this is what you said, I quote, your words, not mine. The problem with the Christian coalition is not that they are Bible thumpers, parentheses, there are personal beliefs that often result from religious experiences, close parentheses, but that they are bigots.
Welcome to Liberty, Watchtower, your front row seat to the pulse of American politics. Here, we cut through the noise to bring you sharp, timely updates, in-depth analysis, and bold commentary on the issues shaping the nation. Whether it's breaking news from Capitol Hill or grassroots movements making waves across the country, Liberty Watchtower keeps you informed, engaged, and ready to think critically. Subscribe and stay tuned. Freedom starts with awareness. Now let's drive in. On Wednesday, the United States Senate Judiciary Committee convened for a judicial confirmation hearing, a critical step in the process of evaluating and approving nominees for lifetime appointments to the federal bench. Among the nominees appearing before the committee was Judge Rita Lynn, nominated by the President to serve as a United States District Judge for the Northern District of California. The hearing was marked by a pointed and, at times, intense exchange between Senator John Kennedy of Louisiana and Judge Lynn, as well as with another nominee, Judge Simmons, who has been serving in California's state court system. Judicial confirmation hearings offer senators an opportunity to probe the background, legal philosophy, and qualifications of nominees to the federal judiciary. These appointments are profoundly consequential, as federal judges serve lifetime terms and rule on issues that can affect millions of Americans, ranging from civil rights and religious freedom to administrative law and criminal justice. As such, these hearings are often rigorous, politically charged, and ideologically revealing. During this particular hearing, Senator Kennedy zeroed in on two major areas of concern. One, the ideological writings and past public statements of nominees, particularly regarding religion and political activism, and two, the practical courtroom experience of those being considered for prestigious federal roles.
Thank you, Mr. Chairman. I have been given 50 seconds to ask each of you questions and to hear your answers, which of course is patently absurd. So I'd ask if you would just answer my question directly. This isn't a question, Judge Gray, I may vote for you anyway, but I'll commit right now in front of God and country to vote for you if you'll move back to Louisiana. Judge Lynn, I've read a number of your writings. I want to, you wrote an article in December of 1998 entitled Person of Faith, Race and Religion as Experiential Knowledge. You wrote it in a journal called Perspective. And this is what you said, I quote, your words, not mine. The problem with the Christian coalition is not that they are Bible thumpers, parentheses, there are personal beliefs that often result from religious experiences, close parentheses, but that they are bigots, end of quote. Did I quote that correctly?
I believe you did.
Did you write that?
I did write that when I was 18 years old, or 20 years old, excuse me. I do want to be clear. I do not agree with that today. I wrote that before I went to law school, before I had any kind of
You were a grown woman when you wrote this.
I'm sorry?
You were a grown woman when you wrote this.
I was 20 years old when I wrote it. It was before I had a professional career.
You were in your third year at Harvard?
I was
a senior at Harvard.
I was a junior at Harvard.
Junior. So you were 3/4 of the way through your Harvard education, and you wrote that.
That is correct, Senator. It is 20 years before I became a judge. I do not agree with it today. I do want to be clear about that.
Okay. Judge Simmons, let me just ask you a couple of questions. You finished law school in 2004?
Yes, sir.
All right. Have you ever tried a case in federal court?
I have not seen there.
Have you ever filed a brief in federal court?
I have not practiced in federal court. My entire practice has been in the state court.
Okay. Have you ever argued a motion in federal court?
I have my entire practice of over 12 years as a prosecutor has been in state court, Senator.
Okay. Have you ever, you serve as a state court judge, have you ever presided over a jury trial as a state court judge?
In the 5 years that I've been on the Superior Court bench, I have been in a moving department, and now I'm the supervising judge.
Have you ever tried a jury trial?
As an attorney, I have tried.
No, as a judge.
As a judge, I have presided over court trials, not jury trials, sir.
No, so the answer is no.
I have not presided over jury trials as a judge.
Judge Lynn came under scrutiny for an essay she wrote more than 2 decades ago while she was a student at Harvard University. In the article, titled Person of Faith, Race, and Religion as Experiential Knowledge, Lynn criticized the Christian Coalition, a politically active conservative Christian organization, referring to them as bigots. Although Lynn expressed regret for the statement and clarified that she no longer holds those views, Kennedy questioned her judgment and implied that such deeply personal and ideological rhetoric could raise questions about her impartiality on the bench. Senator Kennedy also directed a battery of legal and procedural questions to Judge Simmons, focusing on her lack of federal court experience, her limited background in presiding over jury trials, and her familiarity with key constitutional doctrines. Kennedy used a rapid-fire format that challenged Simmons to explain landmark Supreme Court cases and core legal principles such as the Chevron deference, the political question doctrine, and standards of appellate review. While Simmons answered some questions correctly, she faltered on others, prompting Kennedy to raise concerns about whether her background adequately prepared her for a federal judgeship. These exchanges reflected a broader, ongoing debate about judicial qualifications, ideological neutrality, and the influence of past writings or affiliations on a judge's capacity to be fair and impartial. At the heart of Kennedy's questioning was a central question: should a nominee's past words or limited federal courtroom exposure disqualify them from holding one of the most powerful and enduring positions in the American legal system?
Have you, in the 5 years you've been on the state bench, have you ever written any opinions, issued any opinions?
Well, sir, I've been in moving departments in the 5 years that I've been as a Superior Court judge. We don't issue written opinions in moving departments on the Superior
So the answer is no?
In the 5 years I've been on the Superior Court, I've been in moving departments. We don't issue written opinions in moving departments.
Okay. What is the standard of review in federal court for questions of fact?
For questions of fact by the trial court, it is clear error, sir.
Okay. What's the standard of review for questions of law?
In the trial court level, it's de novo.
Okay. What is what's the holding in Map v. Ohio?
In Map v. Ohio, since I've been practicing as a district attorney for the last 12 years, as well as a Superior Court judge over the last 5 years, I know what the holding is. It escapes me as I currently sit here, but
okay.
As a Superior,
what's the Chevron doctrine? You'll see that a lot.
Yes, Chevron deference refers to an administrative agency that's interpreting its own rule. It created a 2-part step test. The first step in that test is whether Congress was clear.
You know it. I got you. What's the political question doctrine?
I have not, as a Superior Court judge, and over the last 5 years, and as a deputy district attorney for 12 years, I have not practiced in a federal court, so if I am so fortunate enough to be confirmed, I will obviously apply the applicable law.
Okay, I want to talk about the United States Constitution. Is it a doctrine of plenary powers or enumerated powers?
Enumerated powers, sir.
Okay. I yield back 1 second, Madam Chair.
Thank you, Senator Kennedy.